Welcome to Queen Mary, University of London, and welcome to this fantastic space, the Octagon, and welcome to tonight's celebrations to mark 60 glorious years of our law school. I'm Professor Frances Ridout, the Director of the Queen Mary Legal Advice Centre, which is our free pro bono student law clinic here in the law school. A little housekeeping first, if I may. You'll see that there's different coloured name badges on different people around the room, and the different colours we have recognise the range of guests that we have here tonight. So staff and former staff are in light blue, current students are in dark blue, alumni are in pink, and supporters of our department are in green. Please do make it your mission tonight to try and seek the full rainbow and speak to somebody with all of the different coloured badges over the course of the night. Now this evening we have two incredibly special and inspirational guests for you. But before I introduce the first of those, I'd like to take a moment to talk about our law school. 23 years ago, I got on the 25 bus from Forest Gate in Newham, just down the road. I came down the Bow Road and went to a taster lecture in room 210 in our law school for an open day. Yes, we do still have 210 for anyone wondering. I started to get drawn into this really quite remarkable place. And after 3 special years on my undergraduate degree, and of course numerous Hail Marys in the student union later, this institution went on to shape my career in ways I could never have anticipated. When I left, plans were already in full swing for the Queen Mary Legal Advice Centre to be formed. And 3 years after graduating, I was back as a qualified lawyer and volunteering to supervise students on our centre's criminal justice clinic. There's a rich history of pro bono legal advice here in the East End of London. Most notably, the first movement of pro bono lawyers, the Poor Man's Lawyer Service from 1898, and that was in Whitechapel. Building on this history with our Legal Advice Centre, equipping students with skills to take into practice, helping members of the public, and perhaps most importantly, giving them that pro bono ethos in their stomach to take forward in their careers. Now that's something that our law school is immensely proud to do. So going back to my story, another 6 years on, I was drawn away from practice and came back here to Queen Mary, but this time as staff. Something, of course, I'm not alone in, because over 10% of the staff in our law school are also QM alum. Now, this statistic really shows the depth of engagement that we have with our alumni body. And of course, talking about alumni, they go on to do a vast range of incredible career opportunities. And our first guest is no exception. Having graduated in 2013, Hamud Mbarak is a Canadian lawyer and poet who shares perspectives of the world through spoken word. He uses his knowledge of the law and his brilliance as a wordsmith to fight for social justice and a fairer world. He described his time at Queen Mary as giving him a greater appreciation of others. And I'm not sure we could ask for a better summary of what we want our educational offering to be. So it is my great pleasure tonight to introduce a really special performance from none other than Hamud Mbarak, also known as Pen Moodz.
Good evening, everyone. Thank you, Fran, for the lovely introduction. But allow me to reintroduce myself. My name is Hamud, but I'm really Pen Moodz. And I'll continue to pen Moodz for as long as my pen moves, until my pen proves that I'm really pen proof. Now, listen and observe as I carve every word and etch my feelings and emotions into every groove. Some sharp, jagged, hollow, some smooth, painting pictures of allegories of different categories that I allude. Your journey with Queen Mary and I on this 60th anniversary is about to begin. And my words of truth and positivity to be continued. So, as my own housekeeping matters, as you can tell, energy is divinely within me. And so in order for me to do what I would love to do up here, I'm equally going to need my energy from you. So, as part of the spoken word practice, the call and receive feedback and response, if something emotionally moves you, no, that's the part where you snap with me. So, here we go. I'm honored to be a part of Queen Mary. I studied here in 2010 to 2013. I made some phenomenal friends. Some are now who are lifelong, who've changed the trajectory of my life. So my presence, your presence, is all a united gift together. So I hope these words do justice to recognize what this institution has done for so many. Because for 60 years, these walls have turned pupils into people before our very eyes. For 60 years, we learned the principles of offer and acceptance. Not bad, right? Our first introduction into contracts at the example of a peppercorn. And within these grounds is where we exercised our knowledge from theoretical to practical, whether at the farmer's market in front of Richard Fielden, to Bow Road Market, or the stalls lined up outside of Whitechapel, or my personal favorite, the magic and mastery of the life and tapestry of Brick Lane, where the spice of life is exacerbated by the excitement and imagination of the inquisitive legal mind, where the price is not what is presented, but what you are willing to offer in exchange. And it is with these lessons that I began to scale the ladder of life, climbing up the rungs. It wasn't until I found myself at the Sky Garden within the Shard, where my head grazed the tops of nimbus-formed clouds, which left me wondering, why? Why can't I go any higher? And it was at that moment I realized the lesson my tutor set before me in every conversation. Whether Rosa Friedman, who showed us the importance of thinking beyond the parameters presented, or Professor Hines, who excavated the philosopher's stone from the crevices of our mind. Each gem of information presented to us to understand that personal growth isn't given, but tirelessly and relentlessly pursued. Which is why, in this pursuit of greatness for critical thinking, commercial fluidity, and legal sophistication, we, East London lawyers, were gifted a single tool far more valuable than any figurine to pass go with on our monopoly board of life. You see, this institution knew better than to gift us with a shovel to go deeper. Queen Mary, our fair lady, the monarch whose vision saw only a future for our band of misfits to truly rise, could only benefit from one item alone. That of the hammer to shatter glass ceilings, to question why, when we have reached the sky, can we not go further, go higher? We no longer question height, we question galaxies. We are legal astronomers who at their might are no longer set by the bounds of gravity. Because we float in space amongst the stars and in an atmosphere so rigorously challenging that oxygen itself fights to exist. But our lungs hold the breath of eternity. So when we speak, the wind bellows in our name. We are children of Queen Mary. We sing her name where we go. We, together on this stage that we stand, recognize that our feet haven't touched the floor. We are floating. We are flying. And through this institution and alongside our distinguished peers, I make this statement. Oh, the places you will go. Oh, the places you will go. Oh, the places we will go. If you dare to wield the hammer to shatter the ceiling above, so that so many more will share the joy that we are so lucky to hold, so lucky to feel, so lucky to be. Boundless. Because here I stand, smiling in front of you, as we prepare to introduce the most respected leader of our legal land to the President of the UK Supreme Court. It's an honor, my Lord. Thank you.
Thank you, Hamud, for that very moving, poetic testament to the law school at Queen Mary where you undertook your LLB studies. We are very grateful. Good evening, distinguished guests. My name is Rachael Mulheron, and I am one of the professors here in the law school. As Fran said in her introduction, it is a great pleasure to welcome you to this, the launch of the 60th anniversary year of the Queen Mary Law School. We hope that you find the evening's events both stimulating and enjoyable. The law school began in 1965 with just 3 full-time staff, including Professor Roger Crane as Foundation Dean, and an intake of 30 students. From those modest beginnings, the law school has over the years graduated many thousands of students who have gone on to such successful careers in the law and elsewhere. We're very pleased to see so many of our alumni here this evening, and we are proud of our students and of their many contributions to legal practice, to law-related professions, to academia, and beyond. There have been many notable events as the law school has grown over its 60 years, and just part of our story is told in the brochure, which I hope many of you have received this evening, and which has been made possible through the generous funding of my wonderful colleague, Ian Yates, whom most of you will know, and who is still an avid and important part of the Torts teaching team here after 59 years. On behalf of the school, I would also like to thank my colleague, Professor Dignam, the chair of the 60th Anniversary Committee, for his tireless work and commitment in making this event and others during the forthcoming year possible. The school is very grateful. Thank you, Alum, for all that you have done and will continue to do. It is now my great pleasure to introduce Lord Robert Reid, President of the UK Supreme Court, who is our speaker for tonight's celebratory lecture. Lord Reid was educated at the University of Edinburgh and at the University of Oxford, where he obtained a DPhil. Thereafter, he qualified as a member of the Scottish and English bars. He practiced at the Scottish Bar between 1983 and 1998, and then served as a judge in Scotland from 1998 to 2012. In 2012, he was appointed as a Justice of the Supreme Court. In 2018, he became Deputy President of that court, and in January 2020, its President. Given Lord Reid's outstanding academic background and his huge contribution as a jurist, we are so privileged that he has agreed to address our students, staff, alumni, and guests on this occasion of the 60th anniversary of the law school. Lord Reid's lecture is entitled, "What are University Law Schools For?" Please join me in welcoming Lord Reid.
Thank you very much, Rachel. I'm afraid I can't hope to live up to your introduction, but I'll do my best. It's a great honor to have been invited to join you in celebrating 60 years of the School of Law of Queen Mary University of London. The question posed by my lecture, what are university law schools for, is one to which Queen Mary gives a convincing answer, as I'll go on to explain. Some of you might wonder why I bother to ask the question at all. Surely, at least one of the purposes of university law schools is obvious: to prepare students for careers as lawyers and judges. But that isn't obvious at all. For many years, the English universities had very little to do with legal training. There were law schools at Oxford and Cambridge by the early 13th century, but they taught only Roman civil and canon law, not the common law of England. Few university law students went on to practice as lawyers. Instead, most lawyers were trained in professional law schools, in particular at the Inns of Court, and through apprenticeships with established practitioners. The inclusion of law in university education was controversial. The vision of thinkers such as John Henry Newman and Matthew Arnold influenced the conception of the university as a place dedicated to learning for its own sake, rejecting narrowly utilitarian and professional agendas. Law was generally seen as a practical discipline, which did not fit neatly within this emergent liberal tradition. There was also resistance from the legal profession, which sought to maintain its traditional privileges and autonomy. As A.V. Dicey observed in his inaugural lecture at Oxford, entitled, "Can English Law be Taught at the Universities?" the general view of eminent counsel, he reported, was that English law must be learned and cannot be taught, and that the only places where it can be learned are the law courts or chambers. Writing about Victorian Cambridge, the former Vice-Master of Trinity College went so far as to say that the law school was generally recognized to be a refuge for those who were averse to intellectual effort. I'd like to think that no one would have said that about Oxford, but the legal historian and philosopher Brian Simpson, who read law at Oxford in the 1950s, recalled that the law school enjoyed a reputation as a dumping ground for very dim young men, often with marked sporting ability. In other words, law was, perhaps unfairly, thought to be a safe haven for rowing blues. It's unsurprising that most barristers had chosen to read classics or mathematics rather than law. As a former law student myself, I'm pleased to say that law has emerged from these doldrums and is now generally recognized as a rich and valuable discipline in its own right. Although I still occasionally encounter some puzzlement among scientists, for example, as to how one can carry out academic research in law, most academics realize, I think, that law is one of the more demanding undergraduate subjects and that it can be the subject of serious academic study. Indeed, Sir Henry Maine, the Regius Professor of Civil Law at Cambridge, demonstrated that as early as Victorian times. Towards the end of his life, Stanley Baldwin, 3 times Prime Minister, was asked by the future Lord Longford whether his career in politics had been guided by the ideas of any thinker. Perhaps surprisingly, since the former Conservative Prime Minister was not known to take much interest in ideas, Baldwin is reported to have replied that the thinker who had influenced him most was Sir Henry Maine. Maine had argued that human history was a process of development in which societies that were based on status were progressively replaced by ones based on contract. It was this grand idea of history as a movement from status to contract, Baldwin said, that had inspired him throughout his political life. But then, seemingly perplexed, Baldwin paused. Or was it, he asked, the other way round? The earliest known English professional law school was established by the mid-13th century. Its students, known as apprentices of the bench, seem to have been attached to the court itself and would watch court proceedings from a raised platform known as the crib. In the middle of the 14th century, legal professional education for both barristers and solicitors was taken over by the Inns of Court. There were around 20 inns, which provided accommodation to the lawyers, statesmen, and civil servants whose work brought them to London when Parliament and the courts were in session. 4 inns, Inner Temple, Middle Temple, Gray's Inn, and Lincoln's Inn, became the most prominent and continue to play a role in the education of barristers today. These were known as the Inns of Court, while the smaller inns were known as the Inns of Chancery. By the Tudor period, the Inns of Court had become known informally as England's third university. After a grounding in an Inn of Chancery, a student who aspired to the bar would seek admission to one of the Inns of Court as a student or inner barrister. Here they could expect what the legal historian John Baker has called minimal tutorial coddling. Students were expected to teach themselves and to help one another. They learned the law by visiting the courts and reading and copying yearbooks and reports, as well as by attending readings, moots, and other practical exercises organized by their inn. They could also try to obtain an apprenticeship in order to learn the art of pleading and conveyancing from a more senior practitioner. Readings were delivered twice a year in the Lent and summer vacations. They usually lasted between 7 and 12 days, spread over a couple of weeks. A barrister of at least 10 years standing would be nominated to deliver a course of lectures on a selected statute. But although the reading would focus on the text of a statute, many readers would take the opportunity to expound the common law piecemeal as the readers reached appropriate trigger words in the legislation. In this way, each reader would illustrate his interpretation of the law. I say his because all the readers would have been men. Women weren't called to the English bar until 1922, following the passage of the Sex Disqualification Removal Act of 1919. Readings were a little like university lectures, but their primary function was to preserve and elaborate key legal propositions without much analysis or comment. Nevertheless, they were important in shaping and refining the common thinking of the students, barristers, and benchers. Case exercises and moots took place more frequently. At Middle Temple, cases were argued every weekday during term, after the midday dinner in hall. One of the benchers would pose a legal problem, raising 2 or 3 difficult questions for the students and the more junior barristers to argue. Students would also put cases to one another as they walked around the temple church. Moots involved more elaborate preparation and procedure in the form of a mock trial, with 2 or 3 barristers or benchers presiding and 2 students acting as counsel. Unlike moots today, they weren't concerned with abstract legal argument, but were instead designed to test the vocational skill of the mooter in framing writs and pleadings. The moot problems were not at all easy. Surviving moot books indicate that they often raised complex questions about the finer points of real property law. The moot men would begin by reciting the pleadings from memory before addressing the points in issue. The judges would then explain the issues and give feedback on the students' efforts. Finally, the mooters presented the judges with a slice of bread and a mug of beer, and the exercise was over. Mooting, in fact, was compulsory for those who wanted to progress. In Tudor times, there were no written exams or formal qualifications for lawyers, and a university degree was not essential, as indeed continued to be the case until very recently. The law lord, Lord Bridge, for example, did not have a university degree. Instead, students graduated to the rank of what was called an utter barrister by performing a pleading exercise at the bar of their inn. This was initially just an internal promotion on the inn's membership ladder and didn't in itself confer any rights of audience in the superior courts. But by the end of the 16th century, it had become the basic prerequisite for practice, much as it is today. This system of professional legal education in the Inns of Court was irreparably damaged by the English Civil War. From then onwards, lawyers were trained primarily through apprenticeships. The Attorneys and Solicitors Act of 1729 required aspiring solicitors and attorneys to enter into an apprenticeship known as an article clerkship for a period of 5 years with a duly qualified practitioner. Written proof of having served articles was needed to become enrolled to practice in either the central or the lower courts. There was no formal requirement that aspiring barristers undertake a pupillage. All that was required was membership of an inn for 5 years, or 3 for university graduates, and attendance at a certain number of dinners. However, most of those who intended to practice served a pupillage of at least 2 and generally 3 years. Neither solicitors nor barristers received any real instruction in legal principles. They were required, as Sir William Blackstone put it, by a tedious and lonely process to extract the theory of law from a mass of undigested learning. Some students joined debating clubs where they could discuss points of law with one another, but these had no formal status within the inns or the universities. This rather uninspiring position continued into the 19th century. Charles Dickens, who was admitted to Middle Temple in 1839, described himself as uncommercially preparing for the bar by having a frayed old gown put on in a pantry and so decorated, bolting a bad dinner in a party of 4, whereof each individual mistrusts the other 3. So in 1846, a parliamentary select committee was established to investigate and report on the state of legal education in England and Ireland in response to widespread calls for improvement. In its report, the committee found that the student is left almost solely to his own individual exertions and that no legal education worthy of the name of a public nature is at this moment to be had in either England or Ireland. It followed that lawyers were inadequately prepared for a legal career or for judicial office. Inspired by the situation in continental Europe, in particular in Germany, the report recommended that universities should play a leading role in the provision of legal education, and that this should be complemented by professional training undertaken in specialist, more technical institutions. A college of law created jointly by the 4 Inns of Court for barristers and a separate but cognate institution for the solicitor. As I've explained, the universities initially taught only Roman and canon law, not the English common law. The first English law lecture series was given at Oxford by Sir William Blackstone in 1753. 5 years later, the Oxford lectures were endowed by the foundation of the Vinerian professorship. Blackstone's view was that law should be taught as part of a broad liberal university education so that students could gain an understanding of legal principles as well as its practical mechanics. But at least initially, common law legal education in universities was a bit of a flop. Blackstone's successors did not attract large audiences at Oxford, nor did the early Downing professors at Cambridge. However, the universities did not give up, and over time, the number of university law teachers and students increased, and new courses were introduced. In 1839, the University of London awarded the first academic degrees in English common law. This was followed by the introduction of the BCL degree at Oxford in 1852, the Cambridge LLB in 1855, and the Durham BCL in 1858. From the early 1870s, law courses were introduced at universities in the Midlands and north of England. In London, the law schools at University College and King's College were followed in 1895 by the founding of a law school at the newly created London School of Economics. By 1933, there were over 300 students studying law as an academic discipline at the University of London and around 500 at Oxford and Cambridge, respectively. These university law schools developed alongside private colleges and crammers designed to help aspiring lawyers pass their professional examinations, which were made mandatory for solicitors in 1860 and for barristers in 1872. The Law Society took over responsibility for the solicitors' examinations in 1877, and in 1903 it established its own School of Law, the predecessor of what is now known as the University of Law. The Inns of Court jointly established the Council of Legal Education in 1852 to offer lectures to aspiring barristers. Teaching was delivered by practitioners and visiting academics until 1967, when the Inns of Court Law School, now known as the City Law School, was established with a permanent teaching staff. Both the Law Society and the Inns of Court schools focused primarily on practical preparation for a legal career. So where does Queen Mary Law School fit into all this? The post-war period saw a rapid expansion in student numbers and a corresponding expansion of higher education generally. During the 1960s, the number of UK universities more than doubled, from 22 to 46. And the course offerings at established universities like Queen Mary also expanded. The School of Law began life in October 1965. It was created following the report of a Robbins Committee on Higher Education, which encouraged universities to seize the opportunity created by increased student numbers to develop broader courses on a new and exciting scale. The then principal of Queen Mary, Sir Thomas Creed, responded by encouraging the creation of the law school. He had himself previously enjoyed a legal career, including as Chief Justice of Sudan. The first dean of the law faculty, as it then was Professor Roger Crane. He was well suited for the job, having already set up a successful law school at the University of Nottingham. Professor Crane was supported by just 3 academic staff, 1 reader and 2 lecturers, one of whom was part-time. The reader was Julian Farrand, who was my external examiner in property law when I was an undergraduate. Julian went on to have a distinguished career as Professor of Law at Manchester and as a law commissioner. He also became the husband of Baroness Hale. I got to know Julian through Brenda, and he became a friend. The part-time lecturer was Cyril Davis, who had just retired after spending many years teaching at King's College. The full-time lecturer was Jennifer Levin, a family law specialist who later went on to serve as the director of the Legal Action Group and to found the law school at Swansea University. That experiment secured her promotion to the rank of professor, something that had been achieved by comparatively few women at the time. Indeed, no woman held a chair in law at a UK university until 1970, when Claire Pally was appointed professor at Queen's University, Belfast. Queen Mary's first cohort of law students comprised 27 men and 3 women, almost all of whom were drawn from England and Wales. In contrast with the position today, there were very few students from an international background. The students spent their first year studying Roman law, constitutional law, the English legal system, and elements of contract law. In their second year, they studied criminal law, tort, trusts, and in most cases, land law. In their third year, they studied jurisprudence and legal theory, together with 3 optional courses. Much of this was typical of the degrees of the time. The content of a law degree at Queen Mary was influenced by the LLB degree offered on an intercollegiate basis by the University of London. And of course, it covered the compulsory subjects then required for a qualifying law degree. But the optional courses included what were then called Mohammedan law and Hindu law, which would not have been widely available. Queen Mary was also one of the first UK law schools to offer a course in the law of social security, reflecting its commitment to providing its students with topical and relevant courses, as well as its commitment to social justice. As one would expect, the number of staff and students at Queen Mary's School of Law and the variety of legal courses and options have expanded significantly since 1965. There are now more than 2,000 students who are taught by over 130 academic staff. There are significantly more international students, as well as significantly more women than there were when the law school opened. Queen Mary is rightly proud to have been ranked by the Sutton Trust as the UK's top university for social mobility. It admits a comparatively high number of students who were eligible for free school meals, and those students go on to have successful professional careers. Indeed, many of Queen Mary's law students have gone right to the top of the legal profession. There are numerous Queen Mary graduates among the KCs in chambers and the partners at top firms, and it's impossible to mention everyone who deserves it. But I'd like to mention some of those who have received a judicial appointment, in particular Sir Christopher Pitchford and Sir William Davis, both of whom became Lord Justices of Appeal, Dame Laura Cox and Sir Joel Benetham, who became judges in the High Court, Brian Doyle, the former president of the Employment Tribunals, and John Finch, the first judge of the Royal Court in Guernsey. Over time, the content of the LLB course has, of course, shifted. Roman law has disappeared from the curriculum, and EU law and human rights have taken its place. The optional subjects now available cover topical issues, such as the law relating to the internet, property and colonialism, class actions, and green finance, among many others. And Queen Mary's traditional LLB is now complemented by other courses, including the 2-year senior status LLB for non-law university graduates. If I were an undergraduate law student today, I'd be attracted by the LLB in global law, which enables students to spend their 3rd year studying at a university outside the UK, in countries including Australia, Canada, China, Hong Kong, India, Singapore, and the USA. The LLB in English and European law, or in English and French law, also provide viable opportunities for study overseas. Queen Mary also provides options for aspiring lawyers who want to gain practical experience. There are opportunities for law students to spend the 3rd year of a LLB on a paid internship at one of a number of partner organisations, which include various law firms, businesses, and the government legal department. The aim is to give students the opportunity to learn practical legal skills firsthand and to enable them to develop a clearer understanding of their career options. Turning to postgraduate study, when it opened in 1965, Queen Mary offered LLM, MPhil, and PhD degrees on an intercollegiate basis with the other University of London law schools. Today, Queen Mary's taught postgraduate programs are thriving. The law school has become the largest postgraduate law school in Europe. In addition to PhDs, Queen Mary also offers a wide range of LLM programs, including some which incorporate overseas study, as well as MSc degrees in law and finance, intellectual property, and regulation and compliance. Many of these courses are taught at the Centre for Commercial Law Students in Lincoln's Inn Fields. The centre was established in 1980 by Sir Roy Good, who I'm delighted to see here this evening. His vision was to bring practicing commercial lawyers and academics together to exchange ideas, and it's clear that many students have benefited from the opportunities he created. Interestingly, Queen Mary is the first Russell Group university to offer an LLM in combination with a preparation course run by the commercial provider Barbary for the solicitor's qualifying examination. Students can therefore choose to combine their academic studies with more practical preparation for the examination for solicitors administered by their regulatory authority. But I asked at the beginning, what is all this for? I'd like to use the rest of my time to say something about why I believe the academic study of law to be valuable, which at times has been a controversial proposition on the Supreme Court, and to comment on the impact that academic teaching and research have had on legal developments. I can begin by referring to a painting by Gauguin in the Museum of Fine Arts in Boston. Its title, translated into English, is "Where Do We Come From? What Are We? Where Are We Going?" Those are good questions for any lawyer or judge to consider. Where do we come from? Sir Walter Scott, himself a lawyer and judge as well as a novelist, wrote in Guy Mannering that a lawyer without history or literature is a mechanic, a mere working mason. If he possesses some knowledge of these, he may venture to call himself an architect. Any understanding of the law today must be based on understanding its history and the history of our society, because the materials on which our law is based, the legislation in the statute book and the cases in the law reports, are the cultural products of a range of periods in our history. Students need to understand that the judgments they study were decided in a specific historical and social context. What are we? Understanding the history of the law and being able to place judicial decisions and statutes in their context is not enough. It's also necessary to be able to think clearly about the problems raised in our own time and their possible solutions. That requires careful thought about the concepts that we use and about the objectives and the social realities which we're trying to capture through those concepts. For example, as those of you who studied tort will know, we don't generally impose legal duties on individuals to protect other people from harm caused by others. But in some situations we do. For example, when a teacher is in charge of a group of children on a school outing. To work out a principled basis for ascribing responsibility in some situations, but not in others, which can be applied consistently, requires very careful analysis of the cases and critical thought. Where are we going? Once we've worked out the enduring principles which can be derived from the materials of the past, and once we understand the problems of our own time and the analytical tools available to us to devise solutions, we have to do our best to develop the law in response to new problems in a way which will set it on a sustainable course for the future. Let me give just one example. A case I decided with a colleague, I think last year or year before last, Wolverhampton City Council against London Gypsies and Travellers. In that case, we held that the courts have the power to grant what are called newcomer injunctions. These are injunctions against persons who are unknown and unidentifiable when the injunction is granted, and therefore can't take part in the proceedings at that stage. And people, indeed, who have not yet done or even threatened to do anything wrong. The context was injunctions obtained by local authorities to prevent unauthorized encampments by unidentifiable gypsies and travellers. But the case also had implications in other contexts where legal wrongs may be committed by individuals who can't be identified in advance. For example, wrongs committed on the internet. At the time the appeal was decided, newcomer injunctions were a wholly new form of injunction with no obvious legal ancestor. However, because the court's equitable jurisdiction to grant injunctions is unlimited, subject to any restrictions imposed by statute, the court could grant injunctions in new circumstances when required by the principles of justice and equity. And that was demonstrated by the court's development of a number of new kinds of injunction over the past 50 years, such as freezing orders in response to the greater ease of transferring capital from one jurisdiction to another, search orders in response to the piracy of intellectual property, and internet blocking orders. We concluded that as a matter of principle, newcomer injunctions should be granted, subject to safeguards that we spelt out, because equity demands that where there is a right, there is a corresponding remedy, and equity can respond flexibly to changes in circumstances over time. Cases like this require time for thought and skill in analysis. Judges and lawyers may not all possess that skill, and those that possess the skill may be under great pressure of time. Academic scholarship is vital to help the courts, both counsel and judges, to arrive at answers to legal problems which are carefully reasoned and reflect an awareness of a relevant social and historical context. I think 3 points emerge from this. The first is that judges need to be able to think clearly about the problems raised in the cases before them and their possible solution. That requires careful consideration of the concepts we use and also of the objectives and the social realities that we're trying to capture through those concepts. The second point is that judges have to decide cases through a process of legal reasoning. That's not the same as economic, social, political, ethical, or indeed any other kind of reasoning. We have laws because we don't agree about economics or politics or morality, but we are generally able to agree that there is an obligation to comply with the laws of our society as applied by the courts. In order to maintain public confidence in the court's application of the laws, they have to focus on the methods of reasoning which are sanctioned by the law. There's a case which those of you who studied constitutional law may have come across about James I. When he became the King of England, James attempted to sit in person as a judge, arguing that the law was founded on reason, and he had reason as well as the judges. The Chief Justice of the time, Sir Edward Coke, tactfully responded that, I quote, "Although God had endowed His Majesty with excellent science and great endowments of nature, His Majesty was not learned in the laws of his realm of England." This, the Chief Justice said, disqualified James from sitting because, I quote again, "causes which concern the life or inheritance or goods or fortunes of his subjects are not to be decided by natural reason, but by the artificial reason and judgment of law, which law is an act which requires long study and experience." This point is critical to public trust and confidence in the courts and in our wider legal system. Legal reasoning results in a distinctive form of decision-making which the public is willing to accept to determine their disputes, because it's clear that the judge's decisions are not based on contested political, ethical, or other values. Those 2 points I've made are about judicial reasoning and argument in the courts, but a third point follows from them, that university law schools are immensely important for the proper functioning of our legal system. To begin with, we need to train lawyers who are capable of understanding the law and of subjecting it to critical analysis through a process of legal reasoning. We derive great assistance from the submissions of counsel in the appeals before us, but we also benefit from academic scholarship. In the past, judges used academic work with caution. As Lord Buckmaster put it in Donoghue and Stevenson, the famous case about the snail in the bottle. The law books, he said, give no assistance because the work of living authors, however deservedly eminent, cannot be used as authority. There was, in addition, a convention among academics at that time of deference to the judiciary. In the 1950s, case notes published in leading academic law journals were famously deferential. Criticism of judicial opinions had to be packaged in mealy-mouthed phrases, such as, "It's respectfully submitted that." The position is very different today. In the Supreme Court, we ask our judicial assistants to identify any notable commentary on the cases that come before us on applications for permission to appeal. Our library provides us every week with summaries of all the latest articles in the leading academic journals. When appeals come before us, we look to academic material, which is often cited by counsel, or if not, turned up by us or our JAs. I find that different types of scholarship can be valuable in different ways. On the Supreme Court, we all have to become generalists because we're asked to decide appeals which concern a very wide range of cases. So I derive great assistance from textbooks and practitioner texts, which provide a map of the territory to be navigated and help me to understand where the issue in the appeal fits. And as my colleague Lord Burrows has said, another benefit is that textbooks provide a relatively neutral analysis, whereas, of course, counsel's submissions are framed in the way that's most beneficial to their client. Doctrinal scholarship can also be a valuable source of ideas. Sometimes academic criticism can prompt the courts to change course. A famous example is Glanville Williams' blistering attack on the House of Lords' decision in Anderton and Ryan on impossible attempts, which prompted the Lords to change their minds only a year later in the case of Shiv Puri. But it's not always appropriate for judges to adopt academic theories wholesale. The House of Lords' adoption of Peter Burke's theory of unjust enrichment provides a cautionary example. Burke's initially adopted a particular approach to unjust enrichment based on unjust factors, meaning that the claimant had to point to a specific factor, such as mistake or duress, in order to show that the enrichment was unjust. But later in his career, Burke's moved towards what's known as the absence of basis approach, which holds that enrichment is unjust if there's no legal basis for it, without any need to identify unjust factors. The trouble was that by the time he changed his mind, the House of Lords had already embedded the unjust factors approach in the law. The courts also make use of non-doctrinal scholarship, or what's sometimes called law and. Legal philosophy, law and economics, law and sociology have all been influential, and it's obviously desirable that judges should reflect on the law not only from a purely legal perspective, but from social, economic, moral, and I think above all, philosophical perspectives. Such research can be of immense value. To give just one example, consider the influence of the legal philosopher Herbert Hart. His inaugural lecture on what he called definition and theory in jurisprudence, which he delivered in 1953, is closely reflected in the modern approach to the attribution of responsibility for companies' decisions, as set out by Lord Hoffman in the Meridian case in 1995. Hart's idea of the rule of recognition as a non-legal norm ultimately underpinning the legitimacy of laws, which he developed in his book The Concept of Law, published in 1961, has been applied by the Supreme Court in important constitutional cases, such as Miller 1 in 2017, concerned with the need for parliamentary approval of Brexit. Hart's 1959 book on causation and the law, which he co-wrote with Tony Honoré, has had a major influence on judicial thinking, illustrated by its citation by Lord Leggett and Lord Hamblin in the Financial Conduct Authority case concerned with the question whether the closure of businesses during the COVID pandemic could be said to have been caused by the outbreak of disease within 25 miles of the business, so as to trigger liability under business interruption insurance policies. So if you're studying jurisprudence, don't think that it's of no relevance to practice. Quite the contrary. In many ways, it's the most relevant subject you'll study. In my own judgments, I've derived assistance from sociological research on the affordability of employment tribunal fees and on the impact of silent protests on staff and patients at abortion clinics, and from research by criminologists into parole board hearings, to give just a few examples. But I think it's important to remember that law and provides us with a way of examining the law from the perspective of a different academic discipline. Law and is, as I say, of undoubted value, but it shouldn't be confused with law, which is animated by a distinctive mode of thinking and discourse. It's important that law schools should continue to produce students trained in the particular methodology, the particular skills of research, and the particular techniques of reasoning, which are distinctive to law as a subject and are different from those of other disciplines. Queen Mary's Law School has made a valuable contribution to legal teaching and scholarship in its first 60 years, as I've explained. I wish the law school a very happy birthday, and I look forward to seeing it continue to light the way forward for students, lawyers, and judges in the future. Thank you.
My name is Alum Dignam. I'm the chair of our 60th anniversary committee. I had sort of two hopes for tonight. I'll tell you about the second hope in a moment. But the first hope, which is a more difficult thing, was that we invited Lord Reid and Hamud. And over the course of the last 6 months, there has been back and forth to try and capture the essence of a law school, because that's the ask. Like, come along, say some things, but say something meaningful. And I think both of them have done such an extraordinary job at capturing and weaving the narrative of a law school, from Hamud's, what it means to him and his hammer, and Lord Reid, who's there, sorry, and what it means in the context of broader education. So we have some gifts for Hamud, if you'd like to come up as well. For both, which we would like to present. Would you like to go that way, or I'll go this way? I'll go this way. For Lord Reid, we have a small token of our appreciation. Thank you very much.
Thank you very much indeed.
For that. And Hamud, we have some flowers. And so, we are going to enter the next phase of the evening, for there is another phase. As Fran said earlier, you all have different badges. The second hope for this evening was that the anniversary committee wanted to put together really an extraordinary group. Our students, our alumni, our staff, former staff, and supporters. Every one of you in this room has contributed in some way to making this law school what it is. You all have badges, as Fran said. They didn't quite come out of the printer like we thought, so I would say, if you are alumni, you have a plum colour, not pink. If you are a student, you have actually uncontrovertibly blue. If you are alumni, seek out students. You can see them, it's blue. They are where you once were. Students, seek out the alumni with the plum colour. They are where you want to be. Staff, former staff are here in really, actually, wonderful numbers to see everybody. They are the glue that holds a law school together, the academics and the professional services staff. Every one of them in this room has contributed to this moment and where we are now. Our supporters are wearing green badges. I think, again, uncontroversially, they're green. Our supporters are the law firms, the commercial organizations, the charities, the local community groups, the regulators, the international regulators. They're all here. Seek them out. See what they do to contribute to the magic that is this law school. Over here, while you're mingling, doing things, there will be drinks and food in a moment, you can see 6 stands. Each one represents part of Professor Rachael Mulheron's East London Tour Landmarks project. They're designed to make you move around and mingle, go have a look at them, look at people's badges, see and sort of enjoy these amazing structures and cases. You'll see as well there is a geographic reference, how far these events are when they took place from this law school, which, as you can see, is right in the heart of the UK's tort law. Finally, I would like to say thank yous, a small number of thank yous, really. There are an extraordinary amount of people who made tonight work and happen over the past year. I'd like to thank Chiara and Dermot from the Principal's events team, who have really held us together in the past month or so particularly. Within the law school, I'd like to thank Gulsh, who is our events officer, who has handled the vortex of communications and everything, and we could not have done it without her. If you could give them a round of applause, that would be great. And finally, while you're wandering around looking at other things, the students are raising money for our outreach projects over in the corner over there. If you want to have a look at the merchandise things, have a look over there. Other than that, the bar is open, there will be food, and I look forward to talking to you all. Enjoy.